Thank you. Thanks, folks. Glad you're all helping here. All right. So the very first thing we want to do, of course, speaking about legal issues, is mention that we are not lawyers, nor do we profess to be lawyers, and we strongly recommend that you contact legal counsel should you have any questions that will directly affect your business after today's program.
Yes, this is something that does affect small businesses, medium businesses, not just large corporations and spammers. So
And
it's definitely,
individuals.
I'm glad everybody's joined us today.
Yeah, thank you, Megan. And on that note, even individuals who aren't even incorporated, it affects them as well. And how come? Because I don't know about you, but yes, it's true. You can face a penalty of anywhere from $1 million to $10 million under the new Canada anti-spam legislation known as CASL. And we, of course, will be providing you with resources and references to everything that we state here today. Let's just get everybody involved right now. So in your message center, that do type in the answer to the following pop quiz questions. Please, everyone engage if you like to. The question is, what is spam defined by our Canadian government? Is it A, a really bad meat-like substance in a can, B, a disease that affects the intestines, or C, any commercial electronic message that is sent without express consent? Enter your answers, please. We'll add up the numbers. All right, excellent. We've got 3C so far. Anyone else? Guess what? You are correct. And it is also really bad meat in a can. So if you answered any of those answers, you were correct. So this is what you need to be aware of going forward in this program today is commercial electronic message and what does it mean? Now, I think what we need to understand is, why was this law passed? Well, it does interrupt business considerably. That seems to be the biggest perception. But more importantly, it's about the fact that we're left vulnerable. And so the government's been working on controlling the amount of what I would call extortion or theft in terms of identity with respect to what people can obtain through email and other means. Megan came across some interesting information, though, that
Well, I mean, really, the key point around this is that spam is the number one criminal activity now, and it really is something that all the countries out there are the main countries out there are trying to do. We are actually the last of the G20 countries to put forward this type of legislation, and that surprised me. I thought we were one of the first, but apparently not.
So on that happy note, let's get into another pop quiz for everyone. So the question is, what is not covered by the Canadian anti-spam legislation? Is it A, telephones? Is it B, fax machines? Or is it C, leaving voicemail messages on telephones? What is not currently covered in the anti-spam law? Okay, we got 2 A's so far for the phone. Fantastic. 3 A's so far. Wonderful. Looking good. And the answer is, guess what? All of them. So no matter what your answer was, you were absolutely correct. You can phone, fax, or leave voicemail as long as you're calling a phone number. So telemarketers rejoice. However, the existing CRTC laws do apply. Megan.
Okay, so now it's really important to understand whether when you're sending an email or a text message, are you actually breaking the law? And the main way is to ask yourself, is the purpose of this to encourage someone to buy something? Are you trying to sell something to someone? If you are, it does qualify as a commercial electronic message.
And that's it. That's the punchline, folks. That's all you really need to know with respect to this aspect of the law. It is an anti solicitation law, right, Megan? Does that make sense?
Yeah, absolutely. And it's not saying that you can't contact people, but it is saying that if you are, there are rules that apply. So you do need to consider, what is your message content? What hyperlinks have you included? Now, this is all emails. This is an email you're just sending from, your name at X company. This is an email you're sending through an email marketing program like MailChimp. Where are you directing them? And what kind of contact information do you have in this message?
Yep. So anything that says that you want to sell something. So further information about what.
So,
Go ahead.
sorry. Okay, so now what qualifies? Having a logo in your email signature, a hyperlink in your email signature, contact information, that does not necessarily mean it's a CEM. However, if you have a tagline that says something like "Buy my new book now," that would qualify as a CEM, even if that's just in your email signature.
Right, a commercial electronic message.
That's right.
So some examples include, go ahead, Megan.
Any sort of offer to purchase, sell, barter, any sort of product or good, land, anything around that. An investment, promoting someone in any way, shape, or form. Those are all commercial electronic messages.
Which I thought was quite fascinating, that now we can't even promote a person anymore. But who's exempt? There are organizations that are exempt from promoting a person, and as well as their organizations. And you should know, folks, that those organizations that are exempt are charitable organizations. They can spam us till the cows come home, as well as political parties. Okay? So we'll clarify your questions at the end of 30 minutes. So please keep your questions coming, and then we'll answer them for you. So there seems to be a little confusion as to what really is an electronic address. Go ahead with your answers. Is it A, an email account? Is it B, an email account and a telephone account? Or is it C, an email account, a telephone account, an instant messaging account, and any other similar account? A, B, or C, folks? Don't worry, we're going to get into some deep, serious information shortly. We just got to keep it kind of interesting. Excellent. Margie says C. And the answer is C. Absolutely. Absolutely.
Yeah, so at this, it's worth noting, this is an email account, absolutely, but this can be coming from a text message, this can be coming from a social media account. It is not just an email address.
Right, so we can use the phone to call people and speak to people, but we can't use the phone to send a CEM, a commercial electronic message, to someone's phone by text.
So I put together some examples because social media, of course, would get everyone's attention as you're wondering, well, what does that mean? Can I not post on Facebook? What can I do? Well, ads absolutely do not qualify. You have an ad on your blog, you post a blog, you post an ad, Facebook ad, anything like that, that's okay, go right ahead. Your wall posts, go right ahead. Where it gets into it is using your social media account for the purpose of sending these electronic commercial messages. For example, in LinkedIn, you can private message people. You can pull their email addresses out of LinkedIn and private message them or send them emails. Those qualify as CEMs, as well as using the Facebook messaging tool that a lot of you may have on your phone also qualifies. So it is what they've said at this point, and I think it's going to come to light as cases start to enter the courts. But it is a case-by-case basis. They really do look at what was used, how it was used, and then from there they will determine if if the complaint is valid. If somebody complains that you are sending them a CEM without permission. So yeah, short answer, you can send messages. There's requirements, and I'm going to get into that.
So the question is, how do I comply when sending a commercial electronic message? Is it A, I have to obtain consent to send a commercial electronic message? Is it B, I have to provide identification information? Or is it C, provide an unsubscribe mechanism? Okay, folks, let's see what your answers are. Oh, Jillian's got all three. ABC from Christian, absolutely, and Andrew, all. Yes, Kelsey. Very good, folks. You've been paying attention. Absolutely, all three you need to ensure meets compliance. Megan's going to get into a little bit more now in this in depth.
Yeah, so I mean, the idea being you want a pull strategy, not a push strategy for consent, meaning, make sure that people are opting in. They want your information. They've asked for it, or you have asked them and they have said, yes, please send it to me. And of course, if you have a pre-existing business relationship, they are a customer, you've worked with them in the last 2 years, then you already have that consent.
Yeah. Woo. Or,
Okay, so there is oral consent. This is not the ideal one. For example, you meet somebody and that you have a conversation and you say, oh, can I send you an email? And they say yes. Great, that's fine, but the problem is how do you prove that if they complain later on? So really, I mean, it's got to be verifiable by somebody else who is standing there, or you've got to record it who does that. So oral consent is not ideal. Now, it is great to start to get the consent, but then once you do that, I recommend immediately sending an email getting that written consent. Go ahead, Pauline, with the next slide.
sorry.
So for written consent, paper and electronic, it's got to be verifiable. Luckily, a lot of these email marketing programs, websites, etc., have the technology that they track when the person filled in the form, and so as long as your forms are legal, you're absolutely fine. You do need to have, if it's a checkbox, like yes, I want to receive email messages from you, make sure that the checkbox is not pre-checked. They have to actually check it. And keep all your written records so that if it ever comes back to haunt you, you can prove, no, this person subscribed on my website this date, this time, here's the proof. And also making sure you do not bundle consent with a bunch of other requests. Like they make a purchase and you just say, okay, well, I'm going to send you information about our legal requirements, and while I'm at it, I'm adding you to my email list. You can't do that. You have to make it a separate option to opt in for your emails.
Exactly. Okay. So, by the way, if you just
for the purpose of, they bought something that requires you emailing them information about that, then you're allowed to email them, of course.
By the way, if you've just logged on, what we'd love you to do, please, is mute your microphone on your telephone, or if you've logged on electronically, please hit your mute button that's available. As we're getting a little bit of feedback, thank you. And then we're going to open up the lines for everyone. Perfect.
Okay, so this is a great example of separating consent. I found this on one of the government websites. So it's just showing, okay, yes, terms and conditions I accept. That's one thing. The installation of the software and the newsletter, they're all separated. And as long as they can manually check that box and say, yes, I'm okay with this, then you're complying.
Yeah. So the days of where it was already automatically checked, like ticked in, saying yes, I agree to receive your emails. Those days are gone as of July 1. Right? It's no longer a default. People actually have to make express consent in this format. So we're going to be enabling you to have copies of this program so you can copy it as well.
Yeah, so just make sure you have express consent, and also make sure that if you send them a consent email, that it has clearly identifies who you are with your full mailing address. And then we have some examples here of emails where they have requested consent explicitly, and the email is that's the only purpose of the email, so it's very clear. And it's flat out saying, click here if you want to receive our emails.
And the other good news about this particular example from a legal firm in town is the fact that it also ensures that every single aspect of this email is compliant with the new laws, right down to the address being stated on this format.
And the unsubscribe button.
Right. Here's an example from the Business Development Bank of Canada. They're covering all their bases to ensure that it's also in French. And here's a nice simple format that we found as well as an example that you may wish to follow.
So we touched on this a little bit, but when you have an ongoing business relationship with another business or another person, you can continue to contact them. Now, the time on that is if they've bought something from you within the last 2 years. Now, friends and family, of course, don't qualify, but you do have to be able to prove that they are your friend. You can't just say, oh, yeah, I know them. Like, there has to be something to indicate that you know them. Anybody who inquires for your services, you're absolutely allowed to email back, and you're allowed to email them for up to 6 months after. And then, of course, anybody within your organization or somebody who has initiated working with your organization, they are allowed to email as well. And as charities exempt and political parties.
All right, another pop quiz, folks. And don't worry about all this information. We're going to be able to discuss it afterwards, all collectively. So what is defined as a personal relationship by the Government of Canada? Is it A, we know each other through social media, B, I like their Facebook page, or C, the real identity to the individual is known in that it's not an alias? You know how some of us have handles on our social media? So we got one person saying yes to all, is that right? Oh no. What's your answers, folks? What's defined by the Canada's new anti-spam law as a personal relationship, please? Is it A, B, or C? Got a couple of C's. Excellent. Yes.
Yeah, so you do know the individual. They're not using an alias of any sort. Just because you share a network with them doesn't mean that you actually know them. Liking their page, anything like that, doesn't mean that you actually know them. You have to you have to really know the person. I mean, it's common sense.
Right, and this is one of the major reasons why I'm a big, huge fan of CRM software, or sales and marketing software like Salesforce, for example, so you can track this data in your system and there's no arguments afterwards if anybody should make a complaint. This is a great point. I'm asked this question a lot, especially myself. I just recently invested in Data.com, which is Salesforce email marketing list, and the answer is no. Just because
likely.
Yeah, well, you're right. Thank you, Megan, for qualifying that. It is not likely that you're allowed to use people's email addresses, even though it's provided on an email list that you've purchased from a third party, okay? But there's more compliance rules that Megan's going to talk more about.
Yeah, so when you're sending an email from yourself, make sure that you provide your full contact information with your address. If you're sending an email on behalf of somebody else or you're working with affiliates, make sure that all the parties involved are identified clearly in the email. And if that gets too much for an email message, put up a little page on your website with that information, and that's absolutely fine as long as they don't have to opt in or something to access that page.
So the bit about we now have to identify ourselves when we are sending a commercial electronic message to someone who has given us expressed or implied consent. Do we need to include in that email our social insurance number, our mailing address, and ensure that the valid mailing address has been in use for a minimum of 60 days? What's the answer, A, B, or C, folks? C? Got a C so far? Another C, excellent. Yep, absolutely. So it's both B and C, so it wouldn't matter which one you answered. We just have to make sure that we include our mailing addresses. Now, of course, there's another vital question about that. What if I conduct my business from home, which of course is extraordinarily popular in the world today? And the answer is no, you can use a post office box as long as you can be contacted through that address. So we're fine there, folks. We don't have to disclose our personal privacy in order to be compliant with this new law. Megan would like to talk about compliance rule number 3.
Yes, an unsubscribe mechanism. Now the key with this is it's got to be easy. It's got to be something they could do in a couple of seconds, whether it's reply to with their text and say unsubscribe, or whether it's hit a button and they can check that they don't want to receive emails from you anymore. But it's got to be easy to use. That's the law.
Yeah, so remember, folks, we're talking about the fact that you've already sent out your email asking for expressed consent for you to continue to send them emails. And then every time thereafter, every single time you communicate with them by email after July 1, we have to make sure that, of course, that unsubscribe button is there. Now, I know for a fact that all the people on this webinar today have been, of course, conducting, this aspect of their business this way.
Yeah, so it's just in every email in an obvious place. That's the key to remember.
And then we have to have a little thing on the bottom of our SMMs that say, if you wish to no longer receive these emails, you can please reply, stop, or unsubscribe. That has to be in the bottom of our emails.
We have a couple examples here, right?
Yeah, go for it.
So here's a good example where you could set it up that they can choose, do they want to not receive any emails or just certain type of emails. So you can absolutely still send them messages of one sort and not another. And this, of course, is an example of a text. And when they do this, when they say they want to unsubscribe, you have to comply within 10 days.
So of course, people are also asking, how do I go on in sales and reach out and approach people about an offer, a new offer that I have? And who can I do that with? So one of the things that Megan and I were talking about was the fact that it looks as though if let's say you're soliciting business and you've noticed that on their website they have published their email addresses under their names in the About Us page on their website. According to how the law is being interpreted so far, yes, they're giving you implied consent to go ahead and email them. And let's say you're at a networking event and they hand you a business card and their email address is on the card, and you ask them, would you mind if I communicate with you by email? And they say yes, that's implied consent. However, as Megan says, make sure that you cover it off with express consent afterwards.
Yeah, with the written consent as soon as possible.
Right, thank you. All right, so the question is, who's going to be the enforcer? Like, who's going to come after us in the event that we aren't compliant with the new law after July 1st? Well, we've got some time on our hands, apparently. Sort of, though, right, Megan? I mean, we have to send out our solicitation of permission email before July 1. Is that correct?
After July 1, sending out the request for permission is illegal.
Right. After July 1, you're breaking the law, which has broken the hearts of many of my clients. I have a client that has 8,000 contacts on their mailing list, and they've only have received so far 364 express consents from that 8,000 list. Okay, so before we open up the lines to talk about this more in terms of clarifying the law, let's talk about what we can do now moving forward. Well, a couple of things to help us with our sales efforts and recruitment efforts is just continue sending your information-rich newsletters. And one of our clients, being J.A. Smith and Associates, an accounting firm based in Nanaimo, they have a fabulous example of an information-rich newsletter, which is completely compliant. Love the phone more, please, folks. Pick up the phone and use it. I personally believe that maybe the underlying reasoning for this law is to ensure that our telemarketing companies, which I'm a huge fan of, continue to thrive in New Brunswick and across the country. As we keep, mentioning over and over again, obtain and record your consent. So use software, folks. Be attractive as a business in Canada and beyond the borders of this country by ensuring that people want to engage with you. How do we do that? Well, start leveraging the media more than you ever have in the past. A great way to put yourself out in the marketplace is to share your articles that you have written with association magazines, for example, with your contact information on the bottom, as they always allow you to do, and ensure that you attract the attention of potential buyers. The minute they contact you, Megan, what was the time period we have where it is considered express consent?
Well, if they've contacted you, you can contact them for 6 months. Although it is recommended within that 6 months that you get them to opt in with a proper form, so that you have that confirmation.
Exactly. And folks, now's your chance. Again, another reason why I think this law was passed. We need to support Canada Post and all the other courier companies in town. And there is nothing more compelling, I found, than sending a postcard to a prospective client for China. I did that once when I was on holidays, and I sent out 1,000 postcards from New York City, and it enabled me to receive the highest feedback rate that I ever had in terms of people wanting to opt in and do business with me. So what else can we
So,
do?
what we're really recommending now is, it's going forward. This sounds a bit painful, and it is a bit painful. If there's more than one person in your organization, maybe you assign a team or a group of people to take care of it. But you got to go through your database. You got to segment it from the people who have expressly complied versus the people who haven't. You got to reach out to the people who haven't to try and get that consent. And if they don't give consent, take them off the list. You got to make sure, go through everything on your website, all your online forms, all your autoresponders, any purchase systems, automatic emails they receive once they purchase. Make sure everything complies with these new rules.
In that they have a mailing address, your mailing address is on that email autoresponder, right, Megan?
Exactly. Going through and just making sure that those three things are on every email, all your autoresponders, everything. So, I mean, the idea is better marketing, and that means good content, which you all know your businesses, and you all have great information to share. And so making sure that you're sharing it in such a way that people, when they come to your website, they come to your Facebook page, they come to your LinkedIn, they see this great content, and they want to receive more of it.
Bingo.
Build the relationships, and focus on them wanting to pull from you. And videos are huge. They're growing. I have some amazing stats around how many people are going to want to buy from you based on just having a really great video on your website, on your YouTube channel.
According to the American Marketing Association, it's 60% of the buying decisions made after they viewed your website and saw a video of the offering that you are providing.
I think it does speak to the relationship marketing side of it, because you're able to, people feel like they know you. Once they've watched you on video, they feel like they know who you are, and then they want to work with you.
So we have some really great resources available for you folks. Here's some of the links that supports all the evidence that we've provided you here with today. There's a fantastic frequently asked question summary that it has been provided as a link for you to research going forward in order for you to be compliant. That's been provided by the government to help you interpret the law. Business in Vancouver is going to be running a six-part series that will be elaborating on what is involved in the laws and what you can do to ensure that you're compliant going forward. So keep your eyes peeled for those articles in BIB. And there's a book that's just been published by a legal firm, two lawyers here in Vancouver, that is definitely worth the purchase of $25, I believe, online. I get no shares in that whatsoever, folks. And I think more importantly than ever, let's work with the relationships we have now and encourage our clients to become recurring customers as well as first-time customers with us by ensuring that we know how to ask for the order the first time. So we'll be hosting a web class on September the 11th of 2014. More details to follow. Now, what I'd like you all folks to do, please, 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 is unmute your phones, unmute your computers. Let's rock and roll here and answer some of the questions that have been coming in. So Jillian, you typed yours out. Fantastic, thank you. And would you like to read your question, or would you like us to read it for you? Okay, she isn't unmuted yet, so I'll read it for you. So is this law only applicable to our Canadian contacts or beyond? We are based in Canada but communicate internationally. So the answer to that, which is fascinating, is that the good news is that this law only affects Canadian businesses sending commercial electronic messages within Canada. So what does that mean? If you have an office outside of Canada and you wish to send a commercial electronic message from a server from outside of Canada to Canadians, you're within the law. Isn't that interesting? Does anybody want to chirp in there? And the reverse is true too. If you are a Canadian company and you wish to send commercial electronic messages to people that haven't opted in or given you consent outside of Canada, again, you're fine. You're within the law to do so. Sound good, folks?
Mhm.
Any other questions?
I have a question. I don't know if you can hear me.
Yep, we can, Margie. Thank you.
Yep. What sort of software do you suggest we use to be sending out these consent emails? Like, does something like MailChimp or Constant Contact, will it be able to have the capabilities of doing this, of sending out the email that they can just click and opt in?
Yes, absolutely. Any of those email marketing programs, almost all of them have what's called a double opt-in feature, and they do have the capabilities for the forms, any of the consent emails. You should be able to set it all up within those programs.
Okay, thank you.
And then one worth mentioning, I'm not sure if anybody here uses it, is Infusionsoft. It is a higher end email marketing program. It's also a CRM program, but the advantage to it is they have very strict regulations for you even bringing in your lists. Like, they really make sure that what you're doing is good, and they really help you with that. So despite the higher price tag, it's really worth the investment.
Good. Any other questions? Or
I have a question.
yes.
What are your thoughts on whether this applies to us marketing jobs or job postings or job availabilities to people who aren't our contacts and we're doing it through email or through LinkedIn?
Yeah,
my understanding is it does apply regardless of who you're sending it to. So if there does need to be the consent, even for job postings.
yeah.
So a job posting falls under the category of what's captured by this?
Is this Chad or Andrew talking?
This is Andrew.
Yeah, Andrew. Yes, we knew you folks were going to be participating today, and Megan and I, did a little bit of research about this, and to be quite frank, it's fuzzy.
Yeah.
Like, in the sense that if you're soliciting people to buy your services, and you're soliciting people that haven't given you expressed or implied consent, right? Then of course you're breaking the law, breaking the story. But if you're just announcing to the public that you have a job posting, right?
Right.
This is where it gets a little gray. Megan, what do you think about that?
Right, and I mean that's why I joined on this, is because I'm really interested in that question. So
Yeah, of course you would. Yeah.
Yeah, and I mean, I guess on that level, it's not going to you're not trying to get them to buy something. You're not trying to sell them property. It's nothing like that. So there is a very good chance that those types of cases are not going to qualify as commercial electronic messages.
I agree, and the reason why I don't think so too, sorry to interrupt you, Megan, but you finish off in a minute, but I think the other reason why, Chad and Andrew, you're going to be okay is the fact that you're sharing information. Okay, so that's why newsletters with absolutely no advertising in them whatsoever is within the law.
Yes, but you still need to be able to qualify where email addresses are coming from. If somebody comes back at you and says, well, why do you have my email address?
Yeah,
And gets offended,
what we could do,
that's where the debate can come in.
we find a lot of candidates on job boards like Monster, Workopolis, and LinkedIn. Because they join those boards, does that mean it's implied consent?
Yes.
Yeah, that I would think so.
I'm not a lawyer, but yes, I would get a lawyer to confirm that for you, though. Okay. My interpretation of it is absolutely it's implied consent. And then, as Megan said during today's program, if you can, try to get express consent from them. Is this helping or making it worse?
Yeah. Well, and what I'm also thinking is, I mean, if somebody's looking for a job and they're receiving an email about a job, then their chances of them getting offended are pretty unlikely. So they're not going to file a complaint against you.
Right, yeah, I mean, I was a little bit more concerned about reaching out to somebody unsolicited, kind of headhunting or poaching them.
Yeah. Well, I think where I have seen is like people are able to contact you because they want to work with you. So if you want to work with them in a hiring situation, then I don't see why you couldn't contact them. It's coming at it from the same approach of you're allowed to email somebody if you're interested in their services.
And it's about, again, it's about, in my mind, of, again, flipping our marketing efforts so that we're just being more attractive out there in the marketplace. So anything that gets people talking about how fabulous you are and the types of jobs that you may have, that may be available through your organization will, of course, increase the number of people that want to reach out and contact you, right?
Yeah. And one thing I'd like to mention here that I don't think I've said yet is referrals. If you got a referral from somebody, you are absolutely allowed to email the person they referred. You just need to make sure you say, oh, so-and-so referred me. So I would think in a hiring situation, same kind of thing. If you're getting their name, you heard about them through someone, you're allowed to reach out to them.
Good point. So Margie's got a question here. Thank you, Margie. I'll just read it out loud because I love the sound of my own voice, as you know. We are a small business that represents manufacturers in Canada, US, and internationally, and provide support to our distributors who sell to the public. How do we factor in?
Okay, so this is around identifying who you are representing when you're sending out the emails. I think you are allowed to do that. If I'm understanding your question correctly, it is you send out an email about these particular manufacturers, but you do need to identify who they are and what their address is and everything. But you're saying I'm representing so and so, and then you're allowed to send out the message.
Okay, does that help, Margie?
Yeah, can you hear me?
I can.
So this is for July to December.
You can write it for how many you want, 1 or 2 or 3 months.
Sorry.
That helps. We do sell some stuff, but our customers are basically our customers that have been over time and eternity. We've had the same distributors for years. So I don't know if we have to establish a new relationship because of this law, if we have to still get their consent when we send emails and
no, I think that if this is people you have been working with, they're on your list and you have emailed them recently, you're absolutely allowed to continue to email them.
Right.
Okay, we don't have to beg for consent or
no, because you have consent from them.
Yeah, that's a great question. We have to wrap up now, folks. Thank you so much for opting in today and actively participating. We hope we've clarified this a little bit further for you. We'll be sending you a copy of this particular open forum webcast, as well as the links that will help answer your questions in far more depth than we talked about. And we urge you to contact either Megan or myself if you need any assistance in going further. So on that note, folks, thank you very much for being here today. It's our pleasure having you as our clients as well. And keep sharing love and being beautiful. Take care.
Thank you.
Bye.
Thanks so much.